Welcome to Weber Gallagher University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. My name is Chris Davis. I'm a partner in the Philadelphia office, and I have the honor of presenting today with Pete Harrison, also from our Philadelphia office. Pete practices exclusively in the area of workers' compensation as well. We're live at Weber Gallagher in Center City. And each month we present a current topic in workers' compensation legal issues. We present both case law updates and ways to manage your risk in your business. If you'd like to view this webinar again, share it with others, or see our other Weber Gallagher University programs, please visit the Weber Gallagher website, which is www.wglaw.com. There you'll find copies of the presentation and others under the Weber Gallagher University page. Also, please feel free to contact us with any questions about today's seminar at questions@wglaw.com, questions@webergallagher.com. So today's presentation is exploring thorny issues with the use of medical-only NCPs. Next month, our topic will be course and scope of employment, key facts to assess and assert the defense. So with that, let's get started with the presentation. So just a little bit of background before we get into the main topic. You know, the Pennsylvania Workers' Compensation Act has been around for a very long time. It goes back to 1915, so we've just had our 100th year anniversary. But it wasn't until 1972 that the Bureau of Workers' Compensation created the Notice of Compensation Payable, or the NCP form, to pay injured workers indemnity benefits. And what it did for the first time was give a unilateral document to the claims handler to issue, where the claims handler would set forth the parties, the average weekly wage, the rate, the description of injury, all the important elements of a claim when a claimant was out of work and therefore entitled to indemnity benefits. However, what a gaping hole existed was the fact that what do you do with the cases where the claimant does not have disability? And the case that started medical-only NCPs in Pennsylvania was a case called Waldemar Park versus WCAB. And this was back in 2003. And what's important about that, the takeaway on that case, is that it involved a case where the claimant clearly had a compensable injury. She worked for an amusement park and injured her hand. And the carrier never accepted the document, the injury formally, but later started denying some medical bills. It forced the claimant to file a claim petition, and the employer answered it, and they denied all the averments, and the claimant was forced to prove all elements of her case, including injury, description of injury, and so forth. Well, when it got to the Commonwealth Court, it approved the unreasonable contest of the case and basically said, well, what the carrier should have done in this situation was issue a medical-only NCP. Now, the problem with that is there was no such thing as a medical-only NCP in existence at that time. So it fell to the Bureau to create one, which they subsequently did. The Bureau revised the Notice of Compensation Payable, which is also known as LIBC 495, to include a medical-only option in 2004. So we've been dealing with the medical-only piece for now about 12 years. In 2011, the Bureau also did an interesting thing. They dealt with the issue of the carrier issuing a notice of denial form. On the old denial forms, you could check one of the boxes and say that you were basically accepting it as a medical only through box 4 and a box 6, I believe. The Bureau didn't want this to be done. They had problems with it. And in 2011, they issued a denial form, amended it by saying that the Bureau is not going to allow it to accept medical-only claims. So now the only way that you can really accept a medical-only NCP is by issuing a medical-only NCP. You can't sort of do the back door that you were able to do a few years ago through issuing the denial form. One of the issues that had historically come up, Pete, and you know this, is that, you know, most of our cases involve medical only situations where the carrier pays one or two bills and then they close the case. One of the fears was that, you know, the adjuster didn't want to have to commit by issuing a medical only NCP form because of the administrative burden in investigating it. What do you do with this form once it's, you know, in the world of the Bureau? You know, where does it go? Can we ever close it? And there was a lot of concerns on the insurance carrier's part about just medical only NCPs in general because of the requirement to commit. So what did the Bureau do?
Well, then they started issuing these medical only TNCPs, which allowed the employer just to accept medical liability for essentially the first 90 days, which is a lot easier to take. So the idea being that the injured worker would potentially treat with the panel physician for the initial period of time. The employer would be able to see what the medical looked like and then essentially be able to deny the claim within the first 90 days if they received a full recovery opinion, let's say, from the panel doctor. And also it gave them the opportunity to investigate the claim and also potentially issue a denial, with the idea being that they're only paying the medical, and hopefully the medical cost is contained through the panel. So it was sort of a friendly way to accept the case, and I think it was needed.
Right. Now, specifically, it was amended by Section 406(1)(d)(1), and the idea and the language used is to start payments for a period not exceeding 90 days without prejudice or without admitting liability where there was uncertainty regarding compensability or extent of liability. So now in Pennsylvania, we have the ability to issue a regular notice of compensation payable. We have the ability to issue a medical only notice of compensation payable. And we have this ability now to issue a temporary notice of compensation payable, which also includes a medical only TNCP. So Pete, do you want to talk a little bit about the actual form itself?
Yeah, the form is basically, it's sent to the injured worker and it's filed with the Bureau, and you can pay essentially wage loss from 90 days from the first date of disability. And you also file with it a statement of wages. So mechanically, that's how it's accomplished.
Right. I think one of the things I've seen in my practice is the most common misstep by carriers is typically they'll issue the TNCP form, but they won't file it with a statement of wages.
That's true. That's and we're going to get into how you amend a TNCP in a little bit. But the statement of wages is something that's overlooked. It should be filed with the TNCP.
Right. And the problem is that we're dealing with time periods. If you issue the TNCP form without the statement of wages and it gets bounced back by the Bureau, then you start getting into situations where time can be against you. You start sort of running out of time on the claim in order to meet the other requirements of the Act, which we'll talk about. Right. So it's very important to issue that statement of wages with the TNCP.
And I guess theoretically, what could happen is the Bureau can bounce the TNCP because you didn't issue the statement of wages. And then you're past the 21 days. And then if a claim petition is filed, a lot of times we'll see a penalty petition filed with it saying that you didn't issue an appropriate Bureau document within 21 days of the injury or disability. So you're really potentially opening yourself up to a penalty situation by not having a statement of wages in there, even though on the one hand you're trying to do the right thing, but you didn't perfect it. So always include the statement of wages. And the other thing is, just for a plug with the statement of wages, if you do go into litigation, we love to have it and the judges love to see it because it looks like you're paying attention to the case. So I think it's a good thing to do in a lot of respects.
That's a good point. So Pete had mentioned the 21-day rule. And for the newer adjusters out there, I think it's worth commenting on what exactly the 21-day rule is. And it comes from Section 406(1) of the Workers' Compensation Act. And it basically mandates that there is a duty to promptly investigate and pay within 21 days. Now, in the world that we live in now, where there's a medical-only NCP and a temporary medical-only NCP, the issue has been, when does the 21 days start?
And really, this is a pretty interesting area of the law that I think most people don't really think about, including the judges, because the Workers' Compensation Act and the Act's regulations talk about the date of disability triggering the 21-day rule. I think that the judges typically run it from the date of injury, and I always give the advice, just to be safe, run it from the date of injury. Case law has talked about the date of injury, even though the Act talks about disability. And Chris, you have something from the Bureau that just came out, and I think that they cause even more confusion.
They do. So the Bureau of Workers' Compensation issues an annual report, and in this year's report, it included a flow chart. And on the flow chart, it talks about a notice of temporary compensation payable and when you have to issue it. And the Bureau takes the position that it's within 21 days from the date the employee provides notification of an injury. Notification of the injury is the triggering date for the 21 days, not necessarily the date of injury. So if you have a situation where you have a date of injury, let's say it's like today is June 1st, but notice isn't given until June 5th, and you have 21 days, and you don't do it within that 21 days of the date of injury, but you do it within 21 days of notice, that can be an effective defense, in my opinion, to a subsequent penalty petition that we're seeing over and over and over in these claim petition cases filed by claimants' attorneys concurrently with the claim petition, which is asserting a failure on the carrier's part to timely investigate and timely file Bureau documents.
Right, and another defense pointer, I guess, is when we see these penalty petitions, they always indicate, well, nothing was filed from 21 days from the date of injury, and I think you can take the position that the defense to the penalty petition could be that it's 21 days from the date of disability. So you could theoretically be paying somebody on a medical-only basis for 30, 60, 85 days, and then decide that you're going to pull it back or an issue with denial, and you're still within your rights to do so because you really don't have disability. And that person, the injured worker, may not even be missing any time until day 80. And so arguably, you have 21 days from day 80 to pull it back. Now, just a word of caution. I think in my experience, I think in Chris's experience also, the judges tend to latch on to the date of injury and are not really thinking about the distinction between injury and disability. But that doesn't mean that we shouldn't be thinking about it. And I think that it will give them something to assess. And a lot of these penalty petitions are just filed willy-nilly, and a lot of times they don't really, they're all boilerplate allegations that really don't say much anyway. And I think that we need to point out to the judges what the law is, and I think that we should have success doing that.
And I think also, just from a litigation standpoint, what I want to do when I'm defending a claim petition is present the employer and the carrier in the best light possible, especially in Pennsylvania, where we know that it's a system that's tilted toward the claimants. So if we can present the employer and the carrier in the best light possible, I want to do that, Pete. I don't want to have any penalty petition issues out there making my client look bad.
And you raise a good point, because a lot of times the penalty petitions file with the claim petition. And when you go to a first hearing, the credibility of the employer is on the line, and that helps to color the case one way or the other. So you want to make a good impression at the first hearing. And if you can say to the judge, Your Honor, my client did everything correctly. We denied the claim timely and consistent with the Act. The penalty petition really is groundless, and it should be denied and dismissed right now. And that way you're making a statement that you're presenting a credible defense. It's not like a case that fell through the cracks and the judge is looking at you thinking, why did you accept the case?
Right.
On the other hand, the judge is saying, well, this employer, this insurance company, this TPA has done everything they're supposed to do. And it gives you a better chance on the claim petition.
Right. I think that, if the judges view you and your client favorably, it'll help you immensely in the litigation that's to come. So there's two issues, right? One is the penalty petitions associated with failure to investigate, but then there's a whole nother set of issues, Pete, and they surrounding pulling the TNCP, because oftentimes the carrier during that 90-day period will want to stop it. So how do they go about doing that?
Well, you have to issue a notice stopping temporary compensation payable and a notice of compensation denial. And they have to be filed with the Bureau. It has to be filed no later than 5 days after the last payment, and also no more than 90 days from the date of disability.
Right.
And again, I'm always cautious, and I say pull it within 90 days from the date of injury. So, and I would still stand by that just as a practical matter. But if we need to extend it, I think it's 90 days from the date of disability. But if you have the time and if it lines up with the injury date, there's no reason to wait. So I think you can certainly do that.
And again, the act of pulling the TNCP can trigger a penalty petition. I've defended cases where the carrier has tried to pull the TNCP, but for one reason or another, they weren't successful. So in one of my cases, I had the carrier issue a notice of compensation denial and a notice stopping temporary compensation payable, file it with the Bureau. Unfortunately, they never sent it to the claimant. And the judge said that that was a violation of the Act, because the Act says that you have to file it with the Bureau and also serve the claimant in order for it to be effective. So the act of pulling the TNCP itself can be very important, both regards to how you file it, who you file it with, and also when you file it. Again, filing it no later than 5 days after the last payment of the temporary compensation payable. So, Pete, you covered the area of mechanically, how do you pull a TNCP? But from a strategic standpoint, what would you say to the adjusters out there about why you would want to pull a TNCP?
Well, one example that readily comes to mind is your panel doctor and or an IME physician provides you with a full recovery opinion. Clearly, in a situation like that, you're definitely going to pull it.
Now, if I'm the claimant's attorney and I argue, okay, you went and you, carrier, you went and you had an opinion, a medical opinion of a full recovery. How can you pull that? How can you take the position that no injury now took place and put the burden on me, the claimant, to go out and file a claim petition and litigate that out, when you know through your own doctor that there was an injury, but you're taking the position now that I'm fully recovered? How can you do that?
There's no case out there that says that you cannot do it. So I think it's completely appropriate. And what you do is you're putting the burden of proof on the claimant to go ahead and file a claim petition and say, I have more than what the IME physician said. But it puts you in a better position, obviously, because you have a denied claim and you're not paying the person. So it puts you in a much stronger position.
Right. Typically, I also see when you get a full recovery opinion within that 90 days, that the TNCP will be pulled. Again, will that trigger a penalty? It might. So that's something to be aware of. Another situation where you might want to pull the TNCP is with a return to work. And Pete, there's two kind of scenarios that play out there, or maybe even three, if you want to comment on that.
Yeah, there's return to work without wage loss. So in a case like that, you're going to pull the TNCP, and you're going to issue a notice of compensation denial. And I would suggest utilizing a box 6 saying that there's no evidence of disability. Basically what that is telling the judge who would be reading this if it's litigated that the person is not disabled under the Act, and that was the reason why the TNCP was issued. And presumably if you're not disabled, you shouldn't be treating medically either.
Right.
And disability is a term of art. It really refers, pretty much relates to wage loss. So I think if you indicate no evidence of disability, that is telegraphing your position sufficiently that there's no liability in the case.
No need to check any of the other boxes on the NCD, just a box 6.
Right. Now, if someone is returning to work with wage loss, how would you handle that? It's a little trickier.
It is a little trickier. Certainly, the regulations and the cases indicate that if you have a return to work with wage loss, you're not allowed to issue or not allowed to pull the TNCP under those grounds. They talk about maybe doing an amendment to the TNCP. I've actually seen some clients issue supplemental agreements in that situation, which I do not actually recommend. I think there's a better way to do it.
See, and what you can do is, let's say, just to throw a little monkey wrench into the situation.
Sure.
You issue a TNCP, you're paying at the total disability rate, and then 2 weeks later the person goes back to work with wage loss. The forms that the Bureau have right now are really insufficient to accommodate that. But what you can do under the regulations is you can file an amended TNCP, and what you would do there is you would indicate in the remarks section that you're paying the person a partial based upon the actual return to work. And when you file the amended TNCP, what you must do is you must file it with the statement of wages, otherwise the whole thing is not accepted. So then you have an amended TNCP and you're paying a partial. And what you can do at that point is you can let this TNCP that's been amended lapse. And in my opinion, what you'll have is an NCP, which establishes that you're paying a partial and that you're paying medical for an injury description which you identified.
Pete, do you think it's possible to pull the TNCP in a situation where we have a return to work light duty with or without wage loss? So you really have no opinion of full recovery within that 90-day period. The claimant might be doing sedentary work with or without a wage loss.
You could do that. And the other thing that you could do is, if you wanted to, is you pull back the TNCP, you'd issue the denial. You could issue a medical-only NCP at that point. And that way, if you go into court, you're telling the judge, we've submitted the most amount of forms that the Bureau allows. So you could say, really, we're doing the most that we could do. And I think doing the most that you could do is really the best advice. So that way, a judge is looking at that. You can tell the judge, we pulled back the TNCP because the person returned to work without wage loss. The person is working light duty. The injury has not completely resolved, and we fully accept our medical liability for the situation. So I think that you're being completely above board, and you're doing the most, and that way you're looking in the best light you can in front of the judge. And you're probably going to pay the medical anyway, so why not get some credit for it?
Right. I would agree with that. So we already kind of briefly talked about this ahead of time, but just so you know, the Workers' Compensation Act does allow for monetary penalties under Section 435 of the Act. Penalties are discretionary with a workers' compensation judge, and the slide ruler, if you will, can range from 0% up to 50%. So you can have a 0% situation where a judge says, yes, there was a violation of the Act. However, I don't believe under the facts of this case that it warrants a monetary penalty. Therefore, it's a 0. Conversely, the judge can find up to 50% due on the compensation owed, which could be a really big number if they think it's an egregious case.
And also, and that's a good point. And then the other thing is, if you're in the 50% range, you're also risking unreasonable contest, which is another 20%, a quantum merit claim where you're paying a reimbursement of an hourly rate,
right,
and also 10% statutory interest. So you're looking at 80% and or up. So it's significant.
Right. So it's significant. It can be very expensive. It can be problematic if these initial bureau forms that are routinely executed and issued aren't handled properly. And some of the examples, really briefly, where penalties have been given by workers' compensation judges is the failure to promptly investigate a claim. That can be a penalty. Also, the failure to issue a notice of denial within 21 days of receiving notice of the injury can be a penalty. And failure to notify the employee within 21 days that the claim has been denied can be a penalty. So, you're starting to see all different ways where these Pennsylvania workers' compensation judges can hit you. And I think it's really important to be aware of, again, when you're filing the documents, how you're filing the documents, and making sure that you can do the best you can to protect, the carrier against these penalties. Amendments to the LIBC 501 temporary notice of compensation form. Pete touched on, it was created in the Bureau Rule 121-7A. The important thing here that I wanted to talk about was that, it still keeps you within the 90 days. It doesn't buy you more time. So if you issue a TNCP and then you issue an amendment where perhaps you're changing the rate or you're changing the description of injury, don't think it's going to buy you an additional time period beyond that original 90 days.
Right.
And you can use the amendment form. It has to be labeled clearly on the top, amendment. And you can do it to switch from the medical only TNCP to a regular TNCP or add additional injuries.
So now we talked about what the regulations say, what the Act says, but we have to deal with the cases. And the cases are completely all over the place. And actually,
that seems so typical.
I know. Actually, when Chris and I were thinking about this presentation, there's a case that came down by the name of Sloan, and it talks about what essentially your rights are with a medical-only NCP. And Justice Collins, writing for the majority in the Commonwealth Court in October of last year, basically said that if you're issuing a medical-only NCP, you are only contemplating accepting liability for medical benefits.
Right.
So Sloan is a situation where there was a petition for indemnity benefits, and the Sloan court said you filed it 3 years past the date of injury, you're barred by the 3-year statute of limitations because by issuing a medical-only NCP, the employer only intended to accept medical in the first place. So it doesn't toll the 3-year statute of limitations. And that makes perfect sense, and that made perfect sense to me because the Bureau created these forms, a medical-only NCP, which to our thinking says that all we really wanted to accept in the first place was medical coverage. We didn't want to buy indemnity benefits, so it shouldn't take a claimant off the hook from filing a claim petition within 3 years of the date of injury.
Right. Now, before Sloan, and I think Sloan was a big win for the employers, but what Sloan did was it kind of rejected an argument that had been floating out there for years, which was when a carrier issues a medical-only NCP, what it does to the indemnity benefits is it places them into a suspended status. And I think that Sloan kind of rejected that idea by saying that the 3-year statute of limitations applies, because if it had accepted the suspension idea, number one, the claimant would have had a different burden. They could have filed a reinstatement petition versus a claim petition, and you have a different burden of proof there. I think it's easier for a claimant to win in a reinstatement context. And also, it takes the 3 years and it extends it out to 500 weeks under the Act. So you've really seen two important things with Sloan. One, cutting down on the amount of time that they have to file, and also addressing the critical issue of what is the proper burden of proof. However, Sloan is issued in October of 2015. Pete, what happens after that?
Well, in March 2016, Justice Collins and much the same court at the Commonwealth Court decides, it's sort of like a little bit of a throwaway remark in the decision, says, and I'm going to read this, because the WCJ and the board found that there was a medical-only NCP, we find no error in their decisions to treat the claim as suspended with respect to claimant's disability benefits, allowing the filing of a reinstatement petition rather than a claim petition. So completely says
180 degrees different.
Oops, I didn't mean that the first time. We don't know. I mean, I think our best advice is to argue that the 3-year statute of limitations applies if an indemnity claim is made off the medical-only NCP. And there's not a Supreme Court decision on this yet, but I think the Supreme Court's going to have to weigh in at some point. In the interim, I think that's a live argument.
Right. I think you want to keep your eyes open and just be aware. The takeaway is just be aware of what can happen to these medical-only claims, 3 years, 4 years, 5 years down the road if a claimant doesn't file. So we are coming to the end of our presentation. I want to thank everyone for attending our webinar, Exploring Thorny Issues with the Use of Medical-Only NCPs. Our next program will be June 21 from our New Jersey office, entitled Course and Scope of Employment, Key Facts to Assess and Assert the Defense. Our attorneys will discuss the approach needed to address arising out of and during the course of employment to allow you to ask the right questions and get the right answers. Again, you can learn more about this program and all other Weber Gallagher events at www.wglaw.com/WG University. Next week, in our Philadelphia office, our employment group will be hosting a program entitled How the New Overtime Rules Affect You and Your Business. This will cover the changes made by the Department of Labor to the regulations that define who and who is not entitled to overtime pay under the Fair Labor Standards Act. These changes will affect millions of employers. There's going to be 2 presentations. One is at 4:30 on June 6th, and the other is 8:30 a.m. on June 7th. If you want to attend one of the programs, you may RSVP to Lindsay at wglaw.com. I'm sorry, blindsay@wglaw.com. So with that, Pete, we're gonna sign off. It was a pleasure.
Thank you, Chris.
And I had a great time, and I hope everyone enjoyed it. Again, if you have any questions, please email them to us, and we'll try to get back to everyone individually.
Thank you.
Thank you.